Good afternoon, everybody. Thank you for joining me. Today, we are talking about reducing our exposure in our New York workers' compensation cases. Hope you're joining me today to learn a little bit about how Section 29 helps us and helps reduce our exposure. So thanks for joining me here today. I'm very excited to talk about this topic. I know you're saying, Greg, Section 29, that's not something normal people get excited about, but Section 29 is a powerful tool for us, and it helps us significantly reduce our exposure in our workers' compensation cases. And whether you have a New York workers' compensation case or you're here to learn a little bit about your reimbursement right or your subrogation specialist, I'm going to give you some valuable information today about how you can help reduce your cost or at least recover some of your costs back, right? So that's the topic that we're going to cover today. I'm going to go through, and I've sort of put this presentation into 4 pieces. First, I'm going to talk about what Section 29 empowers us specifically to do, what's lienable, and which third-party actions you can recover against. In other words, what's unique about this jurisdiction? What does this jurisdiction allow you to do? What does it not allow you to do that maybe you're used to doing in other jurisdictions? I'm going to talk about how your reimbursement credit and offset rights are calculated. And if you're turning off your computers or fast forwarding through your podcast right now, let me just say, I'm going to go kind of have an overview of calculations. I'm not going to kill you with that. Calculations are actually the easiest part of this, but I know people get lost in details. And so I'm not going to focus too much on the actual math. I'm just going to talk about how it really works. And we're going to talk about these concepts of speculative benefits and non-speculative benefits. And so I'm going to do my best to make it as interesting as I possibly can. We're then going to talk about some special cases in New York workers' compensation law or Section 29 law. And I'm going to end up by talking about one of your big powers in this jurisdiction, the power of consent. So first, we're going to talk about what Section 29 empowers us to do. And let's dive right in. What kind of payments or recoveries are subject to our Section 29 reimbursement rights? And the answer is all of them. Section 29 is designed to protect us from the claimant getting a windfall. The claimant's not allowed to bring a workers' compensation claim and also recover in another action for the same loss. That's unfair. That's a double recovery. And that leaves us, the workers' compensation employer or carrier, exposed. So it empowers us to get the money back that we paid in the workers' compensation case, subject to a couple deductions. And it also empowers us to subrogate or bring an action. So let's talk about what that is. First of all, we have a right to recover. If the claimant goes out and brings a third-party action, meaning some other party is the tortfeasor, someone else harmed our employee, and then they collected workers' compensation, we have a right to recovery from that. So if you think about what kind of third-party actions we typically see, it's where the claimant is working for us and gets injured due to the fault of someone else. And it usually comes in the context of motor vehicle accidents, slip and fall accidents, and construction site injuries, particularly those that happen inside the state of New York. Now, the law gives us 3 distinct rights that we are able to obtain as a result of the claimant being hurt by someone else. In other words, not by us, or someone else contributing at least to the claimant's injuries. The first is we have a right to a lien. That means a recovery of the amount we've already spent. The second is that we have a right to offset. So in the future, if the claimant received a net recovery, we're allowed to offset our future exposure. And finally, we have a right of subrogation. That means if the claimant doesn't sue or go after the person who actually harmed them, we can stand in the shoes of the claimant and become and subrogate on their behalf. Now, Section 29 is also self-executing. What do I mean when I say self-executing? I mean that in this jurisdiction, there are no specific court-required notices that we have to issue to someone. In other jurisdictions, perhaps you have to put all the parties on notice of your lien, but in New York, it's presumed that they're aware that the claimant had a civil action, and it's presumed that they are going to pay you back. The last power we have, which is amazing, is that if the claimant goes and settles a civil action or a third-party action without obtaining our consent to it, they waive their right to future workers' compensation benefits. So that's a powerful incentive for them to get us involved and make sure that we're approving of any actions that they're pursuing. Puts us in the driver's seat. So that third party action, and in this jurisdiction, we're always going to be calling it the third party. In other jurisdictions, people call it the action over. What we're really talking about is just that civil action that the claimant is bringing against the party that actually harmed them. And hopefully they do bring that action, but what happens when they don't? Well, Section 29 does give us a right of subrogation. Again, that means we can stand in the shoes of the claimant. Now, there are some unique things that we have to be careful about in this jurisdiction. First, we can't subrogate or step into the shoes of the claimant and become the plaintiff unless at least a year has passed from the date of loss or 6 months after an award of compensation has been made. We also have to make a notice to the claimant. Hey, if you don't bring a civil action, we're going to bring a civil action. We have to give them 30 days to do that. Afterwards, we can then go and prosecute that action. Now, I love to serve these notices on opposing counsel and the claimant. Say, look, you got injured in a car accident. We've been paying you workers' comp benefits. A year has elapsed. You don't seem to have brought suit against anyone for this, but it looks like you were rear-ended in this car accident that occurred while you were working. You've collected workers' comp benefits. You had legitimate injuries. And unless you go and bring a civil action against the party that harmed you, we're going to do that on your behalf. When I send those letters, that usually triggers the claimant. They wake up, they go, oh, wait a second, I could maybe sue somebody, make some money, all right. And then they go and retain one of the plaintiff's firms that advertises on bus stop benches. You know the kind of firm I'm talking about, the ones that advertise during daytime TV. And in this case, they're our friends. We want them to go and hire that plaintiff's attorney and go after the actual tortfeasor, because that's going to give us an opportunity to recover, to get our money back. We're going to get everything that we've paid out in the workers' compensation case, subject to some deductions. So that's something for us to be mindful of, and we want to be proactive about protecting that. Now, there are some special instances, and particularly in this jurisdiction, when the tortfeasor is a public entity. So think about something like a state agency or a municipality or the city itself. When we bring that suit, we are covered by the the act that controls claims against public entities. Please just note that our notice requirements are much shorter. This is one of those reasons why when you think there's a viable third-party claim or claim against another party, you should be really proactive about saying, wait, who is that party? And should we put them on notice early? If we do not bring a notice of the claim to that public entity within 90 days, we may have waived it. And in my experience, the courts are quite stringent about applying this notice requirement. So just be mindful about that when you're going to subrogate against a public entity. All right, so what kind of stuff is lienable? In other words, what kind of costs can we get back, and what kind of actions can we recover against? So let's talk about what is lienable. Well, any medical benefit or money paid to the claimant, even in a denied case, is lienable. In other words, even if a case that we controvert, but we are exposed or liable for medical treatment, or a case that we initially accept and pay lost time benefits in, and then later say, wait a second, this should have been disputed. When the claimant recovers in a civil action, we are entitled to recovery or to be repaid all of those benefits we've issued. We do not have a lien on amounts paid in lieu of first-party benefits, which I'll talk about in a second. We can have a lien on money we pay in terms of a Section 32 settlement. What's a Section 32 settlement? Well, in this jurisdiction, a Section 32 settlement is probably your best friend. It is a lump sum dismissal, one-time payment of workers' compensation that says sayonara to the case, says goodbye, closes or dismisses an aspect of the workers' compensation case. So those instances, we can still recover. And in our practice here, it's we consider it our standard practice in every single Section 32 to protect our right to recover from the amount that we're paying in that Section 32. Well, attorney's fees are lienable, right? Because they are a lien on indemnity. And we will generally argue for things like IME fees and even a nurse case manager fee to be included in our lien, although this is grounds for dispute, but we will try to get that included in the amount that we can recover. Now, the types of third-party actions we can recover from are really very varied, and they're really as varied as whatever harmed the claimant. So yes, you'll see legal bodily injury claims are pretty common, very typical. and we can recover from them. Even things that are quite attenuated, like, for example, in the workers' compensation claim, we authorize medical care, or the case is accepted, so the claimant's receiving medical care. They go to a doctor who performs surgery and harms them. There's iatrogenic harm to the claimant from undergoing that surgery. They're the victim of medical malpractice. They now bring a new claim, sorry, not a workers' comp claim, but a medical malpractice claim against the doctor that harmed them. Yes, we are entitled to reimbursement from the proceeds of that civil action. We are also entitled to any suits against any other employer or coworker for intentional wrongs or harms, for things like hostile work environments or discrimination, basically anything paid under employment practices liability insurance. Yes, we are entitled to be reimbursed subject to a carve-out from recovers from motor vehicle accidents, civil rights claims against the employer or governmental entities. There's a lot of opportunity here for us to get recovery. So in fact, there's so many different types of lawsuits and avenues for recovery that we're entitled to get reimbursement from, that it's easier for me, and it'd be smarter for me to talk about the exceptions. So here are the exceptions. Here are the kinds of recoveries we cannot get reimbursement from. First, any voluntary settlements from the employer's insurance policies without wrongdoing or liability. It's most commonly going to occur in the next context, which is uninsured motorist or uninsured motorist benefits. Those are considered contractual agreements. We are also not entitled to recovery from the Federal Victims Compensation Fund, also called the September 11th Victims and Families Relief Act. We're not allowed recovery for amounts received by the claimant in, quote, in lieu of first-party benefits. And we're going to talk about that in the next slide. And we're not entitled to recovery for loss of consortium awards that the claimant gets in a bodily injury case. And what's a loss of consortium award? Well, let's imagine that our claimant gets injured in a bodily injury case involving a slip and fall on property, and they get an award for $10 million. But they say also they're being deprived of their spouse is getting deprived of their services. It could be household services or relational services. And so for that reason, there's an additional $1 million of loss of consortium award made. Because that award is not really to the claimant, but rather to someone else for their loss of services of that person, we're not entitled to a recovery from that. Now, what this has led to is plaintiffs' attorneys who say, well, we settled the case for $10 million, but Greg, $9 million of that was for loss of consortium. You know, there are court rulings, and I can point you to case law that says that that's ridiculous. That's obviously an attempt to sidestep our right to recovery, and courts have held that that's not appropriate. So where you see a loss of consortium award and opposing counsel is saying that you're not entitled to reimbursement from it, where that loss of consortium exceeds about 10%, we're going to be able to challenge that and likely win. So just be mindful that even though loss of consortium awards are typically not lienable, we can't get reimbursement from them, where they are ridiculous or obviously crafted to avoid our right to reimbursement, we can overturn that. Now, New York also has one other thing, which is called motor vehicle no-fault law, and that's often referred to as the carve-out. Because the carve-out says that essentially when the claimant receives benefits from the proceeds of a motor vehicle policy, the first $50,000 in proceeds are deemed first-party benefits and are therefore allegedly carved out from recovery by us as in the workers' compensation case. And again, the legal theory here is that these are first-party benefits that the claimant's entitled to by virtue of their own insurance policy, and so it's not really a third-party benefit. Okay, it applies retroactively and prospectively. However, there's a lot of exceptions to this, and I'll give you just an example. It's $50,000, but paid out in the first 3 years. So even if they've received less than $50,000, but payments are made after that third year, after 3 years, that's not subject to the carve-out. So there's a little nuance here to be mindful about where there is a motor vehicle claim that you're going to attempt to get recovery from. And also, you might avoid this entirely because you have a separate right to recovery in a commercial case where you have commercial insurance policies. Essentially, insurers have an agreement between themselves to reimburse each other. It's called intercompany loss transfer. And a loss transfer claim can apply in any case involving a commercial vehicle or vehicles that qualify. And there's lots of vehicles that are going to qualify based on what the vehicle is doing or how big the vehicle is at the time of loss. We can then make a loss transfer claim and get that $50,000 carve-out returned back to us, okay? And so that loss transfer is literally moving the amount that we've lost in basic economic loss over to another insurer's mandatory $50,000 policy endorsement. Now, if I've lost you here, that's okay. Don't feel bad that I've lost you because, whoops. If I've lost you, sorry, I pressed the wrong button there for a second. If I lost you, don't worry. Just know that your attorneys, when you say to them, hey, we think we have a right to recovery, they should understand the nuance of that $50,000 carve out, as well as the nuance of that loss transfer law, and make sure you're protected so you get your maximum amount of reimbursement. All right, let's move on to our second topic, which is calculating a recovery. So we already talked about what kind of cases you can get recovery from, what's unique about New York. And again, we talked about those public entity laws. We talked about the notice. We talked a little bit about loss transfer. Now let's talk about how much we get back, okay? And the answer is you get back everything with some holdbacks for the amount that the claimant expended to go and get that civil or third-party recovery. New York lumps all of that cost that it took them to go get that third-party recovery into something they call cost of litigation. It essentially puts disbursements and the attorney's fees all together. And by the way, disbursements, I mean court costs, fees, anything that qualifies. And so cost of litigation gets expressed as a percentage, and it's pretty easy to find out. We'll find that typically from the closing statement. Oftentimes when I'm negotiating a recovery in a case in this jurisdiction, opposing counsel will say, oh, our attorney's fee is X and our cost are Y, and this is our cost of litigation. And I'll say, cool, I'll take your word for it right up until the moment that it's time to cut checks. And then I'm going to need to see your closing statement. And by the way, it's required in this jurisdiction. Every single action that settles a closing statement has to be filed with the courts. It's signed by an attorney, so it's under penalty of rules of professional conduct, ethical violation. And so we can count on those documents to be, to legitimately explain to us exactly what those costs of litigation are. Now, how do you calculate this? Well, let's do an example calculation. We'll do it really quickly. $100,000 settlement, we have a lien, a current lien of $25,000. Where's that coming from? Well, it's coming from that I've already paid that money. I've either paid medical or I've paid indemnity. In other words, money has been moving. The attorney's fee in that case is $33,000 and costs and disbursements of $1,000. And as you can see, I used really easy numbers to come up with a cost of litigation of 34%. So we just simply take our lien, that's the amount that we've spent, which in total was $25,000, and we reduce it by the cost of litigation. That means we get back $16,500. So again, this stuff's not hard. It's not difficult to determine, and you should be able to get good answers here. Now, where it gets a little more complicated is future offset rights. Let's say we have a future exposure in our case. How much do we reduce our payments by, if anything? Well, the answer is we've got to figure out whether these rights in the future are either speculative or not speculative. That's it. That's the next question. The question is, do I have future exposure? If the answer is yes, the next question you ask yourself is, well, is it speculative or not speculative? Because depending on whether that future exposure that we have is speculative or non-speculative, that's going to determine how we're going to calculate how we're going to pay it. And again, this is where it diverges from other jurisdictions. Most jurisdictions don't care. As long as there is a future exposure, most jurisdictions have a simple method for figuring this out. New York has two, because why not? It's New York, right? They like to do what they like to do. All right, so where the future exposure to the work comp carrier is speculative, where it's unknown, we're going to take a holiday. We're going to pay our benefit at the ongoing cost of litigation rate, and we're just going to keep paying until that benefit either expires or becomes non-speculative, or our reimbursement right expires. In other words, our credit is exhausted. Very straightforward. So where it's speculative, and the kinds of cases where it's going to be speculative, let's talk about that, okay? You're basically talking about a loss of wage earning capacity award, a reduced earnings award. That's really the only speculative benefit, right? Or you're paying them temporary partial disability or temporary disability on an ongoing basis. You're currently paying them. Well, you're going to reduce that based on the size of your credit down to the cost of litigation percentage, and that's what you're going to pay. You're going to continue to pay it until either that credit that was left over is completely exhausted, at which time now you're going to pay at the full rate, which is deficiency compensation. It's just really straightforward. It's quite easy when it's a speculative benefit. Now, when it's a non-speculative benefit, and that's pretty much every benefit is going to be non-speculative. I'm thinking about a scheduled loss of use. I am thinking about a permanent total disability case. I'm thinking about a death or dependency case. That future benefit's not speculative. We know what it's going to be. Again, we're going to reduce our current lien by the cost of litigation percentage, so that stays the same. But the next thing we're going to do, because the future benefit's not speculative, we're going to figure out, hey, exactly how much we would have had to pay into the future. Okay, that's a straightforward mathematical calculation. But here's where it gets a little less straightforward. Once we figure out what we're going to be exposed for into the future, that turns out to be what we're avoiding. And once we figure out our avoidance, we then subtract that. And sometimes you'll see there will be fresh money coming in. In other words, we have a gross lien that we have to actually contribute more money because we're avoiding in the future far more cash than we've already expended. Again, sometimes this is a little bit more difficult, but when you're handling an individual case, the attorney that's representing you should lay this out very specifically and tell you exactly why you're issuing this what's called in this jurisdiction fresh money. And then we would simply determine the holiday period. Okay, we're contributing this fresh money. We're now going to avoid all these payments. And then we're going to determine, hey, if this person reaches a specific life expectancy, when would our payments resume? Okay, and in my experience, many times this is academic because we're not going to resume payments for 1,800 weeks or something, 20 years into the future, and so it doesn't matter. But again, this is something that can happen in this jurisdiction where you'll actually have to contribute fresh money in a workers' compensation case where you've already paid because you're avoiding entirely your future exposure. All right, a couple other topics to cover. I'm just going to cover ongoing medical. What happens in the cases of scheduled loss of uses where there's already been a temporary disability credit? Again, these are unique things to this jurisdiction. First, future medical. Well, future medical is really handled the same way any speculative benefit is handled, and that is it is paid out at the cost of litigation rate. How it works practically is the claimant, remember they got this huge third-party award, is going to receive these bills, and we are going to reimburse them at the cost of litigation rate. So if the cost of litigation rate is, for example, 34%, we would be responsible for 34% of that bill. Again, you should be objecting to all the bills that emerge in the case after that third-party settlement is reached, and they should be then reduced to the medical fee schedule and then reimburse the claimant at the 1/3 rate. What really starts to happen, though, practically speaking, when this starts to happen in the cases, the parties come to a conclusion and reach a Section 32 settlement because nobody wants to be going to the doctor, getting the bill, paying the bill at a fee schedule rate, and then turning around to an insurance carrier and saying, hey, now reimburse me 34%. It just doesn't happen in practical world. They would rather get a one-time lump sum Section 32 from you to close out their medical. So that's really how that works. The next sort of edge issue or edge case is scheduled loss of use cases. Remember, hands, finger, feet, and toes, eyes, ears are compensated according to a scheduled loss of use chart. And scheduled loss of use is not speculative. If someone has a 30% loss of the hand, we know exactly what that is. But remember, when we're paying that award for scheduled loss of use, we're already getting a credit for the amount of temporary disability we've issued, which, by the way, was subject to our lien reimbursement. We got that money back. So aren't we getting a double credit here? Well, there is case law, and Caranova was decided in 2016, that says essentially, yes, that would be a double credit. So first you'll get your lien reimbursement, which is already compensating you for the amount of prior indemnity paid, and then we're going to reduce the credit or reduce the amount that you'll get credit for in the scheduled loss of use by that same cost of litigation rate. Okay, so it just, no one comes out ahead based on the Terra Nova calculation. It's a fair way of doing this. Last topic that's particularly unique to this jurisdiction is a topic that I love, the power of consent. The parties have to come to you in this jurisdiction and get your approval, your blessing, your agreement to any third-party settlement that they may reach with any actual tortfeasor. Now, they have to specifically come to you, and this is very rigidly enforced by the courts. The only thing they could do if they fail to do that, if they don't come to you and get your approval first of that settlement they're going to reach, is they can file what's called a nunc pro tunc motion, which is a fussy Latin term that means now for then. They can file a motion in the Supreme Court saying, Your Honor, you should, we didn't wait for their approval, but you should agree that what we did was fair anyway, okay? Again, a chance for us to get some leverage and to maybe maneuver for a global settlement when that happens. A couple other little thoughts here. When we are doing this consent, and I do my consents in writing, there's no such thing as a verbal consent. I'll say, okay, you want me to consent to your civil action, that's fine. Give me all the particulars about your civil action, and I will consent. And I always reserve a few things. The first thing is I specifically explain how my future offset rights are going to be handled or resolved in light of this civil action. The second thing I always say is, how is the current offset going to be applied? Is it dollar for dollar? Am I getting a holiday? Am I not paying? What's happening right now? And the last thing I do is I always say that the consent is effective, or the parties agree the credit begins as soon as my consent letter is sent, which often could be months and months before the underlying Section 32 or global settlement documentation is completed. And that really gives our clients a heads up, or I'm sorry, a jump ahead. So you're giving the other party consent to their civil action, and you say, I'm giving this consent now, but my right to either a holiday or an offset or credit begins today. And the parties can do that. The parties can do that. We don't have to wait for a workers' compensation court to agree or ratify or approve that arrangement. So that's very unique to consents and third-party settlements, that you don't have to really wait for a workers' compensation law judge to hear the case to maybe stop benefits or maybe put a holiday in place where you're literally not paying anymore. So that's something to be very mindful of strategically. All right, last little bits, some takeaways here before I get to questions, and I hope there's some questions today. First, investigate subrogation potential early. I think this is an opportunity for us to be proactive, right? We're not waiting around for them to do something. When a case first comes in at intake, we're immediately diving in and saying, wait a second, is there a potential third-party tortfeasor here? Is there a potential for reimbursement? Next, when you go to the other party and you say, I know that you got a civil action, you got a recovery, good for you, we're entitled to our reimbursement. They love to come to you with this nonsense called 1/3, 1/3, 1/3. They'll say to you something like, well, I've been doing this for 80 years, and we always do 1/3, 1/3, 1/3. That means that you reduce your right to reimbursement by 1/3, and I'll get 1/3 as the attorney, and my client will get 1/3. Isn't that fair? And it does sound fair, right? I mean, it sounds nice, and we want to be nice people, right? We want to seem amicable, like we're nice. But you should never do that. And we never agree. And there is no such thing as 1/3, 1/3, 1/3. Please, if there's one thing you could take away from this presentation, it's that when you get those calls from counsel, ignore them. And when they say things to you like, if you don't agree to doing 1/3, 1/3, 1/3 reduction, we're going to abandon our case because, it's really stinky and he's only going to get 20 grand, and who wants 20 grand, right? Please, everybody wants 20 grand. Nobody's walking away from these actions. If they give a threat to you that their case stinks or they're about to lose on summary judgment or their client's going to leave them, and it's never happened. I've been at this for 23 years, people. You never have to give in to those 1/3, 1/3, 1/3. Next, in this jurisdiction, New York, opponents, adversaries lie. They lie. They lie to judges. They lie to you, my clients. They lie to me. I have to make complaints every so often to the ethics committee about attorneys who have made misrepresentations, who have not acted with candor towards the tribunal, who have not acted with candor towards their opposing counsel. I've had to report people, okay? So we don't trust them. We don't trust opposing counsel. When they tell you, hey, my recovery, my civil action was for $3.9 million, you go, oh, that's great. And then you say, but show me the closing papers, and I get the closing papers, and it's $3.95 million. They forgot about that $50,000. You know, I always wonder, hey, these little lapses, these forgets, these misstatements, they always seem to be favorable to you, claimant, right? So don't take their word for it. Get an itemized closing statement. They are required to submit one to the court anyway, so make sure they do it. Last thing I'm going to say is keeping everybody advised of an ongoing lien. You have a lien in a civil action. You've been paying money in a workers' comp case, and you think you should be getting that money back. Let everybody know. Tell them early. The worst thing that can happen is that civil action is now 2-3 years down the road. Everyone's been silent on behalf of the employer or the carrier, so they don't know how big the lien is. And you get this call as an adjuster, and they're like, oh, we're in mediation. What's your lien? That's too late to address for the first time, right? You really want to get much more proactive about it. Finally, last thing is you've got this power of consent, so use it. All right, let's dive in here. I'm hoping there are some questions typed into my question panel. So I'm going to go open that up now. And we got a good group here. I don't see any questions typed in. So I'm sort of surprised. I mean, look, I got one of my most senior attorneys, Ian's, on this call. I'm surprised that he hasn't typed in a question. And what an opportunity to stump your boss, you know, and see if you can get Greg caught in upside down here, doesn't know the answer. But all right, so no one's taking that opportunity to sort of stump me. That's a bummer. Maybe you're typing frantically and it just isn't coming through. I mean, we all are still recovering, I guess, from the outage last week nationwide. A lot of people had, maybe your computers aren't working today. I don't know. But if you have questions about this topic, or really any topic in workers' compensation law, please feel free to always email me, and particularly about subrogation issues or third-party settlements or recoveries or liens. All right, I've been vamping long enough. Let's see if any questions have come in. Still no, okay, still no. All right, well, thanks for joining me. I know in the summertime, when the weather's great and you're down the beach, you really want to tune into one of these webinars. But let me just remind you, there's other ways to keep up with us if you don't want to tune in live. We do publish all of these webinars on our firm website as both videos and as podcasts. So you're welcome to join that. You can grab a podcast from any platform that serves them as a podcast. And let me just point everyone to my partner Christian's podcast, which is called Third Fridays. Always advanced discussion. He brings in interesting people to talk with on his podcast about workers' compensation cases and topics. So please check that out when you get a chance. All right, I'll see everybody soon. I hope you have a wonderful summer and great weather, and I'll see you in the future at our next webinar. Bye, everybody.